Welcome back to the deep dive. We're here again to really unpack the rules that shape outcomes in the justice system. And today, well, we're tackling something fundamental. It's rare that a crime happens in total isolation. Think about it. You hear about these cases all the time. Someone breaks into a house, right? That's burglary. Then they grab the car keys off the counter and drive off. That's auto theft. And maybe on the way out, they wave a gun at a neighbor who saw them. Aggravated assault, boom. 3 separate charges from one sequence of events.
Exactly. And when you have multiple offenses all tangled up like that, happening close together or as part of some plan, the Texas justice system has a specific playbook. It has to figure out how to manage that legal complexity.
It's not just about guilt or innocence on each charge, is it? It's about the whole process.
Precisely. It's about procedure and ultimately about the sentence. Our focus today is Chapter 3 of the Texas Penal Code. It's titled Multiple Prosecutions. Now, this section might seem a bit dry, but it's incredibly important. It decides if all those charges you mentioned get lumped together in one big trial that's called joinder.
Okay, joinder.
And maybe even more critically, it dictates whether the sentences, if there are multiple convictions, run at the same time concurrently, or if they get stacked one after the other consecutively.
And that difference, concurrent versus consecutive, that's huge. I mean, we're talking about the difference between maybe serving 10 years or, if they stack up, potentially 30, 40, 50 years, right?
Absolutely. It's the operational lever that can dramatically change the real time someone spends incarcerated. So our mission today is to decode these rules for you, break down the legal jargon, and really clarify how Texas manages these complex situations.
Right, let's dive in. Where do we start? You mentioned this whole chapter kind of hinges on one core idea.
It does. Everything flows from Section 3.01, which defines what the law calls a criminal episode. If the crimes committed don't fit this definition, then Chapter 3 just doesn't apply. Each charge has to be handled completely separately.
So this criminal episode definition is the gatekeeper, essentially.
Yeah. It's the absolute foundation. It's the necessary condition before any talk of combining trials or stacking sentences can even begin.
Okay, so lay it on us. What is the legal definition of a criminal episode? How does the code actually define it?
All right, Section 3.01 says a criminal episode means the commission of 2 or more offenses. And here's a key part. It applies regardless of whether the harm is directed toward or inflicted upon more than one person or item of property.
Okay, so it doesn't matter if you robbed one person or 5 people in the same spree.
Correct. The law isn't focused on the number of victims or stolen items per se. It's focused on the connection between the offenses themselves. Did they happen together? Were they part of the same plan? That's the core question.
Got it. Connection is key. And the outline suggests there are basically 2 main ways the state can establish this connection, 2 paths to proving a criminal episode. Let's unpack path 1 first. Sounds like it involves connected actions or a bigger plan.
That's right. Path 1 has 2 subparts, really. The offenses must be committed, 1, pursuant to the same transaction, OR. 2, pursuant to 2 or more transactions that are connected or constitute a common scheme or plan.
Okay, same transaction seems pretty straightforward. Like my earlier example, the burglary, theft, and assault all happening right then and there.
Exactly. That's the easy case. If you assault someone while robbing them, that's clearly the same transaction. But the second part, connected transactions or a common scheme or plan, that's where things get more complex and, honestly, more interesting legally.
Right, because common scheme or plan sounds like you could link things that didn't happen at the exact same moment.
It absolutely can. This is the tool prosecutors use to tie together crimes that might be separated by time or geography, but are strategically linked. Think about sophisticated criminal operations.
Give us an example. How would a prosecutor argue that, say, a series of check forgeries in Austin over several weeks is part of the same common scheme as setting up a fake business in Waco a month later?
It boils down to showing the underlying blueprint, the single criminal objective. Let's say the check forgeries were done specifically to generate seed money for the fake business, and the fake business was set up to launder the money from the forgeries, maybe plus some other illegal activity. Even though the acts are different, forgery versus creating a fraudulent business, happen at different times, and maybe even victimize different entities, banks versus state regulators, the prosecutor argues they are all steps in one overarching plan. Maybe the goal was to defraud investors using the fake business funded by the forgeries. That connection, that plan, makes it one criminal episode.
So path 1 is like seeing the forest, not just the trees. It's about the big picture, the strategy behind the individual crimes.
Yeah.
It allows the state to present a narrative. right? Not just isolated incidents, but a sustained criminal endeavor.
Precisely. It paints a picture of calculated, ongoing criminality. Now, path two is different. It's less about a grand, complex plan and more about, well, repetition.
Okay, so if path one is the intricate blueprint, path two is just doing the same bad thing over and over.
Pretty much. Path two defines a criminal episode simply as the repeated commission of the same or similar offenses.
Same or similar. How is similar interpreted there?
It generally means offenses that share key characteristics or elements, even if they aren't the exact same penal code section. Think of someone who breaks into cars. Maybe one time they steal a stereo theft, another time they just rifle through the glove box looking for cash, burglary of a vehicle, another time they hotwire it, unauthorized use. They're all different statutes technically, but they are very similar actions targeting vehicles.
So examples might be like a shoplifter hitting the same department store every Tuesday, or maybe someone selling drugs repeatedly on the same street corner over a couple of weeks.
Those are perfect examples. The focus isn't on a complex scheme, but on the pattern of repetition of offenses that are either identical or closely related in nature.
It's interesting that this definition has evolved. The outline mentioned it was enacted back in '74, but then significantly amended in '87 and '93. Why the need for updates?
Well, law often has to adapt to changing criminal behavior and, frankly, prosecutorial needs for efficiency. The original '74 language might have been interpreted more narrowly. The later amendments, especially in the late '80s and early '90s, came during periods where concerns about, say, organized drug trafficking or serial property crime were high.
So they broadened it.
Essentially, yes, they clarified and likely expanded the concepts of connected transactions and similar offenses. This gave prosecutors more latitude to bundle cases involving patterns of crime, even if not simultaneous, into a single criminal episode. Part of it was definitely about efficiency, avoiding potentially dozens of separate trials for someone engaged in a continuous course of conduct.
Makes sense. Reduce the burden on the courts, consolidate the cases against one individual.
Right. But it all starts with successfully arguing that the actions meet the definition under Section 3.01, either Path 1 or Path 2.
Okay. So let's say the prosecutor convinces the court, yes, these multiple offenses constitute a single criminal episode. What happens next? What power does that give the state?
That brings us squarely to Section 3.02, consolidation and joinder. This is where the state gets its procedural advantage.
Joinder. The power to join the cases together.
Exactly. Section 3.02a says that once a criminal episode is established, the defendant may, it's usually the state's option, be prosecuted in a single criminal action for all offenses arising out of that episode.
Why is that such a big deal for the prosecution? Is it just about saving time and money?
Oh, it's much more than just efficiency, although that's part of it. The strategic advantage is significant. Think about the evidence.
Yes, sir.
If you have 3 separate trials for, say, burglary, theft, and assault, the evidence in the burglary trial might be kind of dry, and maybe just fingerprints and stolen property. The evidence in the assault trial might be much more inflammatory testimony about threats, fear, maybe a weapon.
Right.
If you join all 3 cases into one trial, the jury hears all of it together. The emotional impact of the assault evidence can easily spill over and potentially prejudice the jury's view of the defendant on the burglary and theft charges, even if the direct evidence for those is weaker. It allows the prosecutor to paint a much darker, more complete picture of the defendant's alleged actions in one go.
That sounds like it could be incredibly prejudicial to the defendant. One really bad charge potentially tainting the jury's view on everything else.
It absolutely can be. And that's why there are procedural safeguards built in. The system recognizes this potential for prejudice.
Okay, so what safeguards are there?
Yeah.
If the state decides to consolidate multiple charges, maybe from different indictments, into one big trial, what do they have to do?
That's covered in Section 3.02b. If the state is going to prosecute multiple offenses arising from the same episode in a single action, and those offenses are charged in separate indictments, informations, or complaints, they have a specific duty. They must file a written notice of the action.
Written notice.
Yeah.
And when do they have to file it?
Not less than 30 days prior to the trial.
30 days. That's not a huge amount of time, is it, if you suddenly find out your single burglary case is now combined with 2 other felonies?
It's really not. 30 days is the statutory minimum. Defense attorneys will tell you it often feels like barely enough time to adjust strategy, investigate the newly joined charges properly, file necessary motions, and prepare for what might be a dramatically more complex trial.
Yeah, I can imagine. Your whole trial prep could be upended.
Yeah.
You need time to figure out how the evidence from one charge might impact the others, maybe prepare motions to try and keep certain prejudicial evidence out, or even decide if you need to ask for the cases to be separated again, which we'll get to.
Exactly. That 30-day notice is a crucial, albeit sometimes tight, window for the defense to react to the state's consolidation strategy.
Okay. Now, Section 3.02 also deals with situations involving retrials, right? What if the state tries a consolidated case, gets a conviction, but then that conviction gets overturned on appeal? Can they just add more charges from the same episode the second time around?
Good question. Section 3.02c puts limits on that. This is often called the rule against sandbagging.
Sandbagging, like holding something back.
Precisely. If a conviction from a consolidated trial is reversed or set aside, and a new trial is ordered, the general rule is the state cannot join any offense in the new trial that wasn't already joined in the first one.
So they can't decide, well, we lost the first time with charges A, D, and C, so now let's add charge D, which we knew about all along, to strengthen our case.
Generally, no. That prevents the state from strategically holding back charges related to the same episode, waiting to see if they win, and then piling on more charges if they lose, just to get another shot or exert more pressure.
Seems fair. But you said generally. Is there an exception?
There is, but it's a very narrow one. The state can join a previously unjoined offense in the new trial only if the evidence establishing probable cause for that offense was not known to the prosecutor when the first prosecution began.
Not known. How high is that bar? Does it mean they just hadn't put all the pieces together yet, or truly didn't know the evidence existed?
It generally means that the evidence itself was genuinely unknown or unavailable. For instance, maybe a key witness only came forward after the first trial, or a crucial piece of physical evidence was discovered later. The state can't just say, oh, we had the police report, but we didn't realize how significant this part was. They typically have to demonstrate that the factual basis for the probable cause simply wasn't in their possession or reasonably discoverable earlier.
So it really forces the state to put all its known cards on the table regarding that criminal episode right from the start.
That's the intent. Procedural efficiency via joinder is encouraged, but not at the expense of fairness, by allowing the state to repeatedly escalate charges from the same event after failing to secure a conviction initially, unless truly new information surfaces.
Okay, this makes sense. We've got the definition of the criminal episode, we've got the procedure joinder with its notice rules and retrial limits. Now let's get to the part that probably matters most to the defendant, the sentencing. How does Chapter 3 dictate what happens after conviction on multiple counts in one of these consolidated trials?
Right. This is Section 3.03, and it's arguably the most impactful part of the chapter because, as you said, it directly translates into years served. This section sets the rules for sentencing when a defendant is found guilty of more than one offense arising out of the same criminal episode, prosecuted in a single action.
So what's the starting point? Is there a default rule?
Yes, there is. And it's generally favorable to the defendant. Section 3.03a lays out the default rule. When a defendant is convicted of multiple offenses in this scenario, a sentence must be pronounced for each offense. However, and this is the key, the sentences shall run concurrently.
Concurrently, meaning at the same time.
Exactly. Serve simultaneously.
Okay, let's make that super clear for everyone. Give us a simple example. If someone's convicted in one trial for, say, 3 counts of forgery arising from the same scheme and gets 5 years for each count, what does concurrent mean for their actual time?
It means the clock starts ticking on all 3 5-year sentences at the same time. The total amount of time they are actually incarcerated is determined by the longest single sentence. In your example, since all are 5 years, the total time served is 5 years, not 15. The shorter, or in this case equal, sentences are essentially absorbed into the longest one.
Right, so the 10-year evading arrest sentence we talked about earlier would absorb the 5-year theft and 3-year mischief sentences. Total time, 10 years under the default.
Correct. That's the baseline protection Section 3.03a provides. Serve the time for the most serious conviction arising from that episode.
But there's always a but in law, isn't there? That default rule has exceptions.
Oh, yes. Big exceptions. Section 3.03a says sentences run concurrently except as provided elsewhere in the section. And elsewhere primarily means Section 3.03b, which lists a whole slew of specific offenses where the judge may order the sentences to run consecutively.
May order them consecutively, meaning they can stack them up back to back.
Correct. For offenses on this list, the judge usually gains the discretion to choose between concurrent or consecutive sentences. And importantly, this applies whether the conviction resulted from a trial or a plea bargain involving these listed offenses.
So the legislature has basically carved out certain types of crimes deemed serious enough to potentially warrant stacked punishment, overriding that default concurrency.
That's exactly what it is. It reflects policy decisions about which crimes, when committed together in a single episode, deserve the possibility of significantly more time.
Let's walk through this list in 3.03b. What kinds of offenses trigger this possibility of consecutive sentences? What's the first category?
The first one, subsection B1, deals with intoxication offenses specifically. Offenses under Penal Code section 49.07, intoxication assault, or 49.08, intoxication manslaughter.
Okay, so if someone causes multiple injuries or deaths in a single drunk driving incident.
Yes. If they're convicted of, say, 2 counts of intoxication assault from one crash, the judge has the discretion to run those sentences consecutively. The policy seems clear. The devastating consequences of intoxicated driving warrant potentially stacking the punishment for each victim harmed.
Makes sense. What's next on the list? It looks like a big cluster related to vulnerable victims, especially children.
Absolutely. This is a major focus of the exceptions. Subsection B2 is quite broad. It covers offenses involving sexual conduct or organized criminal activity, specifically listing several statutes like promoting prostitution, sexual assault, and others, but with a critical qualifier. The offense must be committed against a victim younger than 17 years of age.
The age limit is key. So if the victim is 17 or older, this specific exception doesn't apply.
Correct. For this specific exception, B2, the victim must be under 17. Then we have B2A, which lists section 22.01, sexual assault, and 22.021, aggravated sexual assault without the age restriction.
So any conviction for regular sexual assault or aggravated sexual assault, regardless of the victim's age, potentially allows for consecutive sentencing.
Yes, under B2. And then subsection B3 adds offenses under section 21.15 related to invasive visual recording, often involving children, and 43.26 possession or promotion of child pornography. Again, a clear focus on protecting minors.
Okay, so a strong theme of protecting children and punishing sexual violence generally. What else is on this list?
Subsection B4 is a bit different. It refers to offenses containing an affirmative finding under Article 42.0197 of the Code of Criminal Procedure.
An affirmative finding, what's that?
That's a specific finding made by the judge or jury, usually during the trial or sentencing phase, that a particular fact exists. The most common one is an affirmative finding that a deadly weapon was used or exhibited during the commission of the offense, even if the offense itself doesn't require a deadly weapon as an element.
So if someone commits, say, robbery, and the jury makes a specific finding they used a gun, that finding itself could allow the judge to stack the sentence for the robbery onto another sentence from the same episode.
Precisely. It highlights the legislature's intent to allow enhanced punishment when certain aggravating factors, like deadly weapon use, are formally found to be part of the crime. There's a small caveat for cases transferred from juvenile court, but generally that's how it works.
Interesting. What other categories are there?
Subsection B5 targets human trafficking and related offenses under sections 28.02, 28.03, or 43.05, compelling prostitution. These are seen as ongoing, exploitative criminal enterprises, often involving multiple victims or prolonged abuse, making consecutive sentencing a logical option.
Okay, trafficking, then B6. Looks like injury to specific groups.
Yes, this covers certain forms of injury to a child, elderly individual, or disabled individual under Section 22.04. But notice the qualifier here. It only applies if the specific subsection violated is punishable as a first-degree felony.
So not just any injury to these groups, only the most serious ones.
Correct. Section 22.04 has various levels. This exception is reserved for the highest level, typically involving serious bodily injury or death. It acts as a severity filter. Simple injury, maybe a state jail felony under that statute, would likely fall back to the concurrent default.
Got it. Severity matters. What's next?
Subsection B7 lists offenses under Section 43.235, which relates to improper photography or visual recording, often associated with voyeurism or upskirting type offenses.
So even nonviolent but repeated privacy invasions can potentially stack.
Apparently so. It reflects a modern concern about technology-facilitated crimes. And finally, B8 is a catch-all. It says any combination of the offenses listed in 1 through 7 also allows for consecutive sentencing.
Wow, okay. That's quite a list. Let's revisit that hypothetical.
Yeah.
Burglary, maybe 5 years. Theft, 3 years. And aggravated sexual assault, 25 years. All from one episode tried together. How does this list change things?
Well, aggravated sexual assault, section 22.021, is explicitly listed in subsection B2A. That means the judge immediately gains the discretion to stack. The burglary and theft sentences, assuming they don't fall under another exception, might still run concurrently with each other, but the judge could potentially stack the 25-year aggravated sexual assault sentence onto whatever the effective sentence is for the other two.
So instead of the default 25 years total concurrent, the judge could potentially make it closer to 25 plus 5, maybe 30 years, or even more depending on how they structure it.
Potentially, yes. That's the power. Section 3.03b grants the judge for these specific offenses. The concurrency protection is removed.
Okay. Now, besides that list where the judge may stack, are there situations where stacking is mandatory?
Yes. Section 3.03c carves out a specific scenario involving repeated serious assaults where consecutive sentences are required.
Mandatory stacking, what triggers that?
This applies if, in a single criminal action, the defendant is convicted of more than one offense under Section 22.02, which is aggravated assault. But there is a further condition. Each conviction must be for an aggravated assault that is punishable as a first-degree felony, specifically under subsection B4 of 22.02.
Okay, what kind of aggravated assault is punishable under 22.02b4?
That subsection often deals with aggravated assault committed against a public servant or against a family member or dating partner if the defendant has a previous conviction for certain family violence offenses. It targets repeat serious violence in specific contexts.
So if someone is convicted in one trial for 2 separate first-degree aggravated assaults against, say, police officers during the same incident, those sentences must stack.
According to 3.03c, yes, the judge has no discretion there. The legislature has mandated consecutive sentences for that specific pattern of extreme violence.
That sends a very strong message. Okay, there's one more complex part here, subsections D and E, dealing with human smuggling and related crimes. This sounds complicated.
It is a bit intricate, yeah. It sets up a kind of hierarchy. It applies when a defendant is found guilty in the same action of 1. Certain human smuggling offenses, let's call these the A offenses, specifically Section 20.05A2 or related ones.
Okay, A is the core smuggling crime.
Right. And 2, they're also convicted of certain other specific offenses that arise out of the same criminal episode, things like certain types of assault, criminal mischief, burglary, theft, evading arrest, hindering apprehension that are connected to the smuggling. Let's call these the B offenses.
So B offenses are crimes committed sort of in furtherance of or alongside the main smuggling A offense.
That's a good way to think about it. Now, here's the rule under D2. The sentence for the A offense, the smuggling, may run consecutively with each sentence for the B offenses.
So if the smuggling involved stealing a van, theft B offense, and assaulting a border agent, assault another B offense, the judge could stack the theft sentence and the assault sentence onto the smuggling sentence.
Yes, that discretion exists under D2. The facilitating crimes can be added consecutively to the core smuggling crime.
But then there's a twist in D3. Right. What about multiple smuggling counts?
Ah, yes, the crucial counter rule. If the defendant is found guilty of more than one A offense, multiple counts of the core human smuggling itself, those A sentences must run concurrently with each other.
Okay, wait. So if you're convicted of smuggling count 1, 10 years, and smuggling count 2, also 10 years, those have to run together for a total of 10 years for the smuggling part.
Correct. The legislature decided the core smuggling enterprise counts should run concurrently. But then the judge could still choose to stack the sentences for any associated B offenses, like the stolen van or the assault, onto that concurrent 10-year smuggling sentence.
Also, like the core smuggling charges form one block of time, and the other related crimes can be tacked onto the end of that block.
That's a perfect analogy, and subsection E just clarifies that these complex A-B rules apply even if the convictions came from a plea agreement, not just a trial verdict.
Fascinatingly complex. So the state has this power to join cases via joinder, potentially leading to concurrent or, for many serious crimes, consecutive sentences. What can the defendant do about it if they think joinder is unfair?
That brings us to the defendant's main defensive tool in this chapter, Section 3.04, the right to severance.
Severance, meaning splitting the cases back apart.
Exactly. Section 3.04a provides the general rule. When the state consolidates charges from the same criminal episode under Section 3.02, the defendant usually has a right to request a severance of the offenses. They can ask the judge to order separate trials for some or all of the charges.
Why would a defense attorney do that? We talked about how one big trial might seem more efficient. What's the strategic thinking behind demanding severance?
It's all about minimizing prejudice. Remember our example of the inflammatory assault charge potentially tainting the jury's view on a weaker burglary charge?
Yeah.
Severance is the remedy for that. By splitting the cases, the defense ensures that the jury deciding the burglary charge hears only the evidence relevant to the burglary. They won't be influenced by the potentially shocking details of the separate assault case. It's about getting a cleaner trial on each individual charge, hoping to avoid that spillover prejudice.
Okay, so you trade the efficiency of one trial for the potential fairness of separate trials, hoping to isolate the evidence for each charge.
Precisely. You're trying to prevent the jury from making what's called a cumulative culpability, essentially deciding the defendant is just a bad person based on the totality of the charges, rather than evaluating the evidence for each charge independently and rigorously.
But requesting severance isn't a free lunch, is it?
Right.
What's the catch? What happens to those sentencing rules we just spent so much time on if the cases are severed?
That's the crucial trade-off outlined in Section 3.04b. If the court grants severance, the specific sentencing rules of Section 3.03, including that favorable default rule of concurrent sentences, do not apply to the severed cases.
Whoa. So if you sever the cases, you lose the guarantee of concurrent sentences for those offenses that weren't on the exception list.
Correct. Once severed, each case stands on its own for sentencing. The judge then falls back on their general sentencing authority and may order the sentences for the convictions from the now separate trials to run either concurrently or consecutively. You basically give up the Section 3.03 protections.
So the defense has a really tough calculation to make. Risk the prejudice of a joint trial, but keep the potential benefit of concurrent sentencing under 3.03. Or demand separate trials to avoid prejudice, but risk the judge deciding to stack the sentences anyway, using their general discretion.
That is the strategic tightrope walk. It depends heavily on the specific facts. If you have, say, 3 similar, relatively low-level property crimes joined together, the risk of prejudice might be low, and keeping the concurrent sentence protection is probably wise.
But if you have that burglary joined with, say, an unrelated but very emotional charge like injury to a child,
then the risk of prejudice from joinder might be so high that severance becomes almost necessary, even knowing you're rolling the dice on consecutive sentences if convicted in separate trials.
Makes sense. But is this right to severance absolute? Can the defendant always demand separate trials?
No, it's not absolute. Section 3.04c carves out significant limitations, especially for the most serious crimes.
Connecting back to that list in 3.03.
Exactly. The right to severance generally does not apply if the offenses joined together are those serious crimes listed back in Section 3.03b, or C, the ones involving intoxication, manslaughter, serious sexual assaults, child victims, trafficking, mandatory consecutive assaults, etc.
So for the very crimes where the state can seek consecutive sentences, the defendant generally loses the right to split the trials apart.
That's the general rule. The legislature has essentially decided that for these most serious offenses, the state's interest in efficient prosecution and presenting the full picture of the defendant's conduct in one trial outweighs the defendant's usual right to severance based purely on potential prejudice.
That seems tough. Is there any way out for the defendant, even in those serious cases? Can the judge still grant severance?
Yes, there's a final safety valve. Even for those offenses listed in 3.03, B, or C, the judge retains the discretion to order severance or provide other relief if the court finds that the defendant or the state would be unfairly prejudiced by joining the offenses.
Unfairly prejudiced. That sounds like a higher standard than just regular prejudice.
It generally is interpreted that way. It's not enough to just say, this other charge makes my client look bad. The defense usually needs to demonstrate a specific, articulable reason why the jury simply cannot be expected to consider the evidence for each count separately and fairly. Maybe the evidence is so complex or so emotionally charged, or the legal defenses are so contradictory between the counts that a fair trial is impossible if they are joined.
So it's a high bar, but the judge still has the ultimate power to ensure a fundamentally fair trial, even if the statute generally denies severance for those serious crimes.
Correct. It's a constitutional backstop, ensuring due process isn't completely overridden by the statute's preference for joinder in serious cases.
Okay, we have covered a lot of ground here, really digging into the nuts and bolts of Chapter 3. Let's try to distill this down. What are the absolute key takeaways listeners should remember about how Texas handles multiple prosecutions?
All right, four main pillars, I think. First, it all hinges on the criminal episode. That's the gateway. Are the offenses connected by transaction, scheme, or repetition? If not, Chapter 3 doesn't even come into play.
Got it. Pillar 1, criminal episode definition. Pillar 2.
Pillar 2 is the procedure, joinder. That's the state's tool to combine qualifying offenses into one trial. And remember the safeguard, if they use separate charging documents, they need to give the defense at least 30 days written notice.
Okay. Episode, joinder, and notice. Pillar 3 has to be sentencing.
Absolutely. Pillar 3, sentencing rules. The default is concurrent sentences serve the time for the longest single count. But that default gets overridden for a specific list of serious offenses in Section 3.evo3, where the judge may, or sometimes must, impose consecutive stacked sentences. That list heavily targets violence, vulnerable victims, and organized crime.
Right. Default concurrent, unless it's on the bad list. And Pillar 4.
Pillar 4 is the defendant's counter. The right to severance. Generally, the defendant can ask to split the trials to avoid prejudice. But,
Right.
and it's a big, but this right is limited for those same serious offenses listed in 3.03. And exercising severance means losing the protection of the Section 3.03 concurrent sentencing rules. There's still a judicial override for unfair prejudice, but it's a high bar.
Episode, joinder, sentencing rules, concurrent versus consecutive, and severance. That really maps it out.
You know, the complexity here really highlights something fundamental about our legal system. The process, how we group crimes, how we try them, how we sentence them collectively, can be almost as impactful as the definition of the crimes themselves. Chapter 3 is proof that procedural rules can dramatically shift the outcome, turning years into decades based on how the system decides to bundle the charges.
That's a powerful point. The procedure isn't just red tape. It's where the leverage and the consequences often lie. And that leads us to a final thought for you, our listeners, to chew on. We focused today entirely on the rules within Chapter 3 and the courtroom procedures. But think about this. How might factors outside these specific rules, things like, say, disparities in funding for prosecution versus defense, or the existence of mandatory minimum sentences for certain prior convictions, or even political pressure surrounding certain types of crime, how might those external forces influence a prosecutor's decision to seek joinder aggressively, or influence a defense attorney's strategic calculation about whether to risk severance? How do the realities outside the courthouse shape the application of these powerful rules inside it?
Definitely something to think about. How the game is played often depends on resources and pressures beyond the rulebook itself. Thanks for joining us for this deep dive.